let's start with maybe the procedural posture of what this case, where we are, Netchoice v. Paxton. The Texas legislature and the Florida legislature both passed bills that are very similar, despite what the Fifth Circuit has said, because the 11th Circuit has stayed, through a stayed an injunction or upheld an injunction at the district court level to not enforce the Florida law as facially unconstitutional, with the exception of some transparency rules. The Texas legislature and the Fifth Circuit passed a similar law to restrict platforms from what the Texas law says is censoring content. And that, largely was based upon, I think probably solely based upon, everybody on the, I don't care to get into the politics of it, but it does seem that the history of it is that in Texas, there was the perception that, Twitter and Facebook and YouTube were unfairly discriminating against conservative viewpoints, whatever that means. I try to avoid, saying anything too political about these issues, because I honestly don't have strong enough opinions on some of these things, because they're so new, they're so rapid, they're so changing. But that is sort of the impetus for these bills, is the perception that certain individuals, certain groups of thought, certain messagings, narratives were being unfairly discriminated against in favor of something else. That alone is interesting because, there's no shortage of conservative content on Twitter, as far as I know. I do not engage on social media platforms, so some of this is I have to just kind of read about, because I do avoid engaging in social media. But I can't be ignorant of it, of course. Well, anyway, an industry group, Netchoice, which is represented by YouTube, Facebook, and Twitter, and there are other groups that would be in that group, other organizations within a group, sued to facially challenge the constitutionality of the Texas law, HB 20. The district court issued a preliminary injunction that was appealed to the Fifth Circuit. The Fifth Circuit issued, let's see, I forget exactly what the process is. The Fifth Circuit stayed the injunction without an opinion, which alone is an interesting thing to do. I'm not an expert in civil procedure, but if the Fifth Circuit or any appellate court, sort of reverses a district court without an opinion, it becomes difficult for the parties to know what to appeal next. So that decision to stay the injunction got appealed to the Supreme Court. The Supreme Court did the shadow docket, which I don't even like that phrase, but issued reinstated the stay of the injunction pending an opinion from the Fifth Circuit. And people were kind of in limbo. The Fifth Circuit issues this opinion, which people are heavily criticizing. And then another interesting procedural point, and I don't know enough about this, if this is how this works, but I think it's unusual. Then the Fifth Circuit, without telling the Supreme Court anything about this, said, no, we have reissued our stay of the injunction. I would think that something would have to, again, I'm not a constitutional expert in these types of situations, but I would think that the Fifth Circuit would have at least had to say, hey, we've issued our opinion to the Supreme Court. And then maybe there would be something, I'm not sure. But anyway, as it stands, the Fifth Circuit has reinstituted its own stay of the injunction. So now that's sort of where we stand.
Dr. Firestone.
Yeah.
Last night I was trying to count how many times the the law was off and on and off and on. And if you start with it off, then it was passed.
Yes.
It's on, then there's an injunction, then it's off, then there's a stay, then it's on, then the stay is reversed, and then it's off.
Yes.
And then the reversal of the reversal, or the opinion itself,
Yes.
and now it's back on. And of
Yes.
course, now with the circuit split, who knows if it will get turned off again.
I mean, and at the outset, let me make it clear, I have no sympathy for the social media platforms. I believe that they have, made plenty of money doing things that are unethical. You don't have to go far to, find examples of this in the news that go even beyond any content moderation, of course. But I do have sympathy for them to try to figure out what to do next. And also, let's make clear that no trial has happened yet. Let's make that clear. And the reason why is because the law that the legislature passed seemed, and I read the law when it got passed, like last year, or even like when it was in committee, because people are saying, hey, these types of laws are going to be passed. So I was like, okay, I'm going to read what they are. I'm guessing my initial reaction was much like most others. Oh, this has to be unconstitutional. And here we are with a circuit split. So at least at this point, and again, it was a 2-to-1 vote. The Fifth Circuit's was all 2-to-1 votes, and even within the 2 votes, there was not agreement on certain rationales to uphold the vote. So we even have that in play. So I guess I can pause just for a minute here if there's any questions so far, because that alone, and I always tell my students, I'm no expert in civil procedure, but that alone is just sets the table for sort of an interesting story, doesn't it? Or that alone is an interesting story, no matter what the content of the law was. Right?
Absolutely.
I'm gonna drink my coffee too, just a second. But going on after that, if there's no questions, why are so many people saying this is I forget what that quote was, but I think Rosenstein said something, and Eric Goldman has said something like the singularly worst opinion ever written about the First Amendment. Honestly, when I read it, the opinion, there's that point, I suppose, in law school where, at least for me, it hit about the end of the first year or the start of the second year, when you're starting to read opinions that are, circuit opinions, federal Supreme Court opinions, and you're starting to read them and you're like, well, that's just not right. The first few cases you're reading is just trying to understand how things work. And eventually you get comfortable enough and you're like, well, that's not right, is it? That can't be true. That doesn't make any sense. It is true that the majority opinion and the concurrence opinion, because there's 3, there's also the dissent. It really is hard to read. There are internal inconsistent logic, there are inconsistencies with logic, a lot of logical arguments that are very questionable, just with facial, and just reading them without any context, it seems very hard to understand. And so my quote is from my favorite film critic, Roger Ebert, who famously, when he reviewed The Empire Strikes Back and was talking about Yoda and how he talked, he said, and backwards ran sentences until reeled the mind. And it's kind of the way I felt after reading this opinion. And again, I in no way want to disparage, federal judges. It's just that it's really hard to read, and it really doesn't, at least in not only my view, because I'm no First Amendment expert, but it really does not state the law. And it's, again, we're not even at the trial, right? We have a whole, we have probably years of litigation ahead of us, and it's just, it is really hard to parse. And I do feel some sympathy for the people on the other side, because it's like, okay, where do we start now? Because this was it seemed like it was so obviously unconstitutional, but now what, right? And the reason why I wanted to bring this up as a topic is what scares me is some other commentators, and this is because I'm just not in tune with all of this, have said that opinions that are like this, and I don't want to say anything about, you know, content, political nature, opinions like this have been bubbling up into higher and higher levels. And so my concern is that it creates a sense of uncertainty and at least in the marketplace. You know, how should companies behave or plan for the future if something that we thought was so clear, at least most people who have studied these issues, if it's now no longer that clear because you can have a circuit split pretty quickly, what does this mean? You know, if the Supreme Court doesn't step in to, you know, resolve a circuit split here, what does it mean if some of these statutory provisions stay in play? So we can get to some of that because we haven't even talked about what the law is and what it says, right?
Dr. Firestone, I don't know if you wanted to start with Section 230, but I do
Sure.
have a question. This might be a good place to pose it.
Sure.
Along those lines. So Section 230 specifies that platforms shall not be treated as the publisher or speaker of user-generated content. But then they argue essentially that their moderation or even censorship is speech protected by the First Amendment. So are they trying to have their cake and eat it too?
Well, certainly if that's the case, if it's cake and they were eating it, they were certainly doing so for roughly 26 years. The only reason that this has come up is because the Florida and Texas legislatures have said, well, that's just not the way it is. The Texas law, so 230, yes, 230, the history of 230 it was part of the Communications Decency Act, which was primarily struck down as unconstitutional by the case ACLU v. Reno, which was a 9-0 Supreme Court opinion, by the way. It was the 230. So the overall law was generally aimed at trying to protect children from pornography, and not just children, but, you know, adults from obscenity. And the Supreme Court held that the restrictions on you know, knowingly transmitting material to underage or minors, people, that was unconstitutional. You cannot let you know, you can't know who's an adult, you know, because there was a knowingly part to the law. I don't know where my message is going to be viewed. You know, it was both overbroad and under inclusive. There was, you know, so all of that was struck except the 230 element. 230 was part of the bill in response to a case where Prodigy Services was held liable for content that it maintained on its bulletin boards because they moderated their content. They were active, you know, these were the heady days of 1994 when only a very few number of people were on the internet. It was just becoming bigger and bigger, such that, you know, people were getting dial-up internet at home. And there the court held, and not up to the Supreme Court, but it made it to a circuit level opinion, that because Prodigy was moderating its content, the defamatory, it could be held liable as a republisher of that material. And that was considered to be a negative result because it either would, and this is exactly what everybody's been talking about, what these laws that Texas and Florida have passed are going to have the potential to do, or are likely to do, is that it will discourage content moderation. The goal of 230 was to encourage content moderation to make the internet a more acceptable place to everyone in general, and to not make a whatever the internet provider, whatever the service is, right, whatever that application is or website is or app platform, and again, platforms did not exist in 1996. Let's also bring that up. That 230 has two prongs. One, that the platform and the the internet, the definitions, but it encompasses platforms and websites will not be treated as a publisher of that material that is not theirs. If it's third-party content, they will not be treated as the publisher. The other thing is that they will not be held liable for moderating content, because we want people to do that. So, if it's having your cake and eating it too, I suppose that's true. The scope, and again, what is 230? It's a statutory liability immunity shield. The purpose of it, again, is to quickly end lawsuits related to this activity. Without it, you could go through trial and maybe end up with the same results. Whatever was alleged to be defamatory could ultimately be deemed not defamatory and no liability. But as you can imagine, without Section 230's liability shield, every person, every website, every platform, every app will face far more lawsuits and have to defend them. That alone, right? That's just one thing. And that was a policy choice. Don't get me wrong, that's a policy choice. We as a country and as a Congress said, we like our iPhones. We like the internet. We think it's cool, and we don't want to step in the way of this innovation with all of these litigations, right? We don't want that. It is a policy choice. Don't get me wrong. And also don't get me wrong, I have no sympathy for the platforms for what, I enjoy some of their technology, no doubt. And the scope of that immunity is certainly broader than I think it should be. It's been extended to situations that go well beyond defamation, right? It's been extended to one of the strangest ones to me is Airbnb ads. If you have a home and you have a home or a condominium and you have a homeowners association, and in that agreement, it's not allowed to rent your condo or house via Airbnb, a newspaper can be held liable for that if you put an ad in the newspaper. But Airbnb was held to not be liable because that's third-party content, and Section 230 provides an immunity shield. So there's just certain things that I'm not sure the scope of the immunity really makes sense for, because that never existed in the first place. We really are treating the internet, and our casebook author, James Grimmelman, says Section 230 really is like the first internet law, except for the Computer Fraud and Abuse Act, I suppose. It's just like, this is saying the internet is different. The internet is a different thing, and we are treating it differently as a policy matter, right? So that is the history, a little bit of the history of Section 230 and why. In my mind, at the very least, I don't understand why, if material has been legally adjudicated to be defamatory, I'm still not clear why Section 230 should apply to allow that immunity shield to leave that material up. Note that none of this applies to criminal law, federal criminal law. None of this applies to intellectual property issues and things related to sex trafficking. There's, as I always tell my students, intellectual property is different. It's always different. It's always treated differently, especially with the internet.
Dr. Firestone, we do have one question that would probably be good before we move on. You mentioned that the scope of Section 230 immunity is, in your opinion, broader than it should be. Do you have ideas on what a reasonable scope of immunity would be?
You know, people who have studied this far longer than I have really struggle to think of how to, if we were to amend 230, you know, and leave it in place as opposed, you know, if somehow the Supreme Court would try to resolve this circuit split by saying, no, actually, all of the CDA is unconstitutional, including 230. Right? So if somehow the Supreme Court decided that, it would be one thing. But if we were talking about amending that piece of legislation, it is very difficult to understand how to change it without creating unintended consequences. And so there is this balance of what would you rather, you know, in my mind. At the very least, I think that an amendment that says, you know, Section 230 does not apply to material that has been adjudicated by, you know, a court of competent jurisdiction, that the material is defamatory. I feel like that somehow, I know that would be problematic for certain reasons, but that alone seems like at least something that we should be doing. It seems almost ridiculous to me that if you get a judicial notice that, hey, your website is hosting defamatory material, that you don't have any obligation to remove it or sort of de-index it. It seems strange to me. That at least I feel like is something we should look at. Any other changes will run the risk. You know, what we will talk about what some of the risks are, because basically the Texas and Florida laws sort of say, well, 230 doesn't really exist with respect to, you know, certain types of platforms. So, so I can go into some of the issues. You know, what is a social media platform under the Texas law? It is at a threshold, it is defined as a service. So it can be email, an online service app or application or website that consists primarily, or I'm sorry, that's the exception, right? It's an internet website or application which is open to the public. Again, that phrase is there to trigger common carrier concerns. Allows a user to create an account, enables users to communicate with other users for the primary purpose of posting information, comments, messages, or images. It does not include email or any of those types of online services that are primarily for news, sports, entertainment, or other types of information content, which is not user-generated or pre-selected by the provider. For which the chats and the comments, the user, you know, the interactive functionality is only incidental to or directly related to or dependent on the provision of the content. So alone, there is an interesting distinction that's been made. This law targets only, at least it's intended to target, only social media platforms where the primary purpose is to you know, where users can share content, their own content. So that's, you know, where that line is drawn is interesting, right? You know, it seems like they're trying to say, well, ESPN.com is not this, but why would that matter if they have comments, right? I mean, you know, whatever website, you know, they're imagining, you know, I don't visit like weather.com, but if weather.com has, you know, comments section, I don't know why that, you know, but so then there's this other hook of 50 million users per month, which in some of the briefs I didn't read, but it was mentioned, you know, a relatively arbitrary figure, but it was intended to sweep in, you know, Facebook, Twitter, and YouTube. Eric Goldman has pointed out that would also sweep in TikTok, Snapchat, Pinterest, Reddit, Skype, LinkedIn, Microsoft Teams, Discord, Twitch, Zoom, right? Zoom, iMessage and FaceTime, Wikipedia, Vimeo, and the gaming platform Steam.
Interesting.
Those all at various points. And again, it's per month. So 1 month you don't, and 1 month you do. If you're, again, it's again, that definition alone is problematic for several reasons, but we can kind of skip past that and just assume we could just say, like a court would say, well, let's just assume that's a good definition, even though it's already, even though there's plenty of problems with it. Well, con law, First Amendment 101. What does the Bill of Rights apply to? What is the Bill of Rights? First Amendment is a restriction on government action. So any situation like this that's arisen in the past where laws have alleged that something online has censored, again, censor or content moderation, plenty of people have talked about that. It's the government. There has to be government action to violate the First Amendment. There are other ways that can happen through private conduct. I'm not a First Amendment scholar, but there are ways that private action can have the color of government action, just as the Fourth Amendment can. So the baseline, what everybody's like, well, there's Twitter and all of the internet basically is privately owned. There are government websites, but the vast majority of the internet is privately owned. How you get to the internet is privately owned. Again, there are government websites, no doubt, but all of the internet is private. So in order to say that somehow there's no, so what the court and the Texas legislature end up saying is, so the core of what really is driving First Amendment scholars crazy is that the law says you cannot, ban, block, deplatform, in any way, like shadow ban content from users that is viewpoint based. Well, what does that mean? I'm an idiot. Anybody that would be on Zoom at this early in the morning is stupid. That's a viewpoint, I think, right? Let's leave Ellie, right? Sure. So if I start posting in the chat, you're all idiots, we gotta leave it, right? It's we can't block that, can't get rid of it because we're on Zoom. There's 50 million users a month, right? And that's like the best of, like, the First Amendment and First Amendment jurisprudence in America is unique in the world. England has something, views the freedom of speech something like how we view it, but the rest of the world just kind of thinks we're crazy. What counts as legally protected speech at the margins is stuff that generally horrifies other people and countries and nations, right? No one can understand why we would want to let the Nazis march in Skokie, right? Nobody, they just don't get that. They're like, that's just insane, right? But that's what makes America, unique, and we rather, like, we believe in the marketplace of ideas, right? That's sort of the idea.
And we do have a much broader view of the First Amendment than most of the world, which, when we're talking about the internet spanning the world, can create some interesting conflict between what we want on the internet and what other countries don't want on the internet.
You see it all the time. That's why people talk about the splinter net or balkanization. interesting enough, it starts with, probably started with defamation, right? Australia is known as having a very, very pro plaintiff rules on defamation, and it's what people are saying. What if Texas passes a law like this, but New York passes a different one, and California and Utah and Nebraska and all this in Colorado, right? Like, it's really hard to divide the internet geographically within a nation, especially when you consider some of the constitutional issues. It's a little easier to do it and more justifiable to do it around the globe. And you see different things on the internet from country to country. So first of all, our First Amendment views are just, the point I was getting is what is protected legally in the United States at the margins, includes things like things that are very close to like harassment, what the line between what is, protected speech versus harassing or bullying, cyberbullying is, is close. The court says, the court has one quote here that everybody's been pointing it out. It's where's the quote? It basically says that the platforms are obsessed with neo-Nazi speech and terrorism, and if you can't if you can't block material that is neo-Nazi and supports terrorism because it's viewpoint based, right? If it's not illegal, if it doesn't isn't inciting somebody immediately to violence, right? It's and if it's not otherwise illegal, if it's you can't moderate that. And the court, one of the first things that people are just like, oh, you got to be kidding me. Like, as soon as the internet existed, even with BBSs and dial-up modem pools, there were neo-Nazi bulletin boards. Some of the, I've got a video from like 1995, when the internet first became commercial, and there were already neo-Nazi websites, right? So it's the people are saying, well, what, where is that coming from? Because if a platform says I'm going to block your posts because it promotes terrorism, well, that's viewpoint based, right? So I'm an idiot. That's viewpoint based, right? Welcome back, flame wars, right? It's you remember in the earliest days of flame wars, and then eventually Facebook would be like, come on, you guys got to separate and take a timeout or whatever. Well, just if you can't, what is and what is not viewpoint based, if a platform can't make that, if a platform doesn't, the 230 was encouraging people and platforms to moderate that content. Anybody that studied this, it seems like, and again, I haven't done the work, says without content moderation, to get rid of this material at the edges, most places devolve really quickly into the worst kind of stuff, because people like to troll. People will do stuff just to do it, even if they don't even really believe, right? There's people that really believe it, that want to post these messages. There's people that are just being trolls to do it. There are automated bots that'll do it. And the people that want to join a community to talk about stuff will leave. So that is really, when people say, boy, geez, what is going on here? Oh, the platforms are, they've gotten away with so much for so long. I'm not saying that there shouldn't be something, something should be changed about what goes on online. But without this ability to moderate content, most platforms will face the choice, which will be, we can't moderate content. because we won't know for sure whether or not it's illegal from the get-go, right? How do you know something's defamatory? Well, only when it's been adjudicated to be defamatory. How do you know that something is illegal speech? And you know, they're fairly, you know, YouTube's gotten fairly good with respect to copyright issues, but how do they know, you know, in fact, Facebook and Twitter are being sued, or Facebook and YouTube are being sued for promoting terrorist speech, which has and the families of some victims of terror attacks have been suing Facebook and YouTube for that. So it's just really strange to say that the platforms are obsessed with blocking terrorist speech and neo-Nazi speech and what, you know, whatever else at the margin you want to talk about, because that's there all the time. It's perpetual.
Dr. Firestone, we have a question from Heidi that says, what is keeping social media platforms from clearly stating things that will be censored? And I know the text, I didn't read the Florida law.
Yeah,
I did read over the Texas law, and I don't have it memorized, but I know in there, one of the first things it talks about is a transparency thing. Like, I think they want the social media to kind of state what it is that they're going to censor and then be transparent about what they're censoring. So again, this question, what is keeping social media platforms from clearly stating things that will be censored?
If you're a First Amendment scholar, you would say, well, I don't have to do that because compulsory speech violates my First Amendment rights. My editorial discretion, you know, the people say, well, newspapers don't have to explain to you why they rejected your letter to the editor. You know, so at the very baseline, there's an argument that they don't have to, and it would be unconstitutional. These mandatory disclosures are compulsory speech, which violates the First Amendment itself. That hasn't been litigated, but that's just the baseline. Most of the platforms do have an acceptable use policy because they want to establish goodwill with their users and then explain some of the decisions. Well, they do that. But clearly, I notice, is the operative word there. Most platforms will try to explain, and certainly, like, I don't go onto Reddit, but even within each subreddit, they have, you know, more active moderation within those groups. And it's maybe even clearer there because they're such specialized groups. Facebook got what it wanted. They've got the globe online. Try to navigate, what is it, 193 nations laws and cultural expectations and views on morality. Hey, they got the problem. Again, this is why I don't really have too much sympathy for them, because hey, they got what they wanted, right? They have the world on Facebook. Okay, your job, this is your homework. Everybody put on your lawyer, I'm compliance attorney for Meta. By next week, you have to clearly explain what we will or will not allow on our platform. They're trying. Clearly, I don't know. It's how do you do it? How do you know what's illegal? Obscenity, like, what is obscene? Is takes a judicial determination. What is defamatory takes a judicial determination. Whether or not something violates copyright law should take a judicial determination, but that process is largely automated, at least on YouTube, where they've got, you know, ways to detect video or audio content that matches registered works. But you have to fight upwards to claim fair use, or, you know, transformative use, or that it was also an original work prior, right? So even that alone is difficult to do.
We have a follow-up question too, and I think it gives rise to a part of the case where it talks about Section 230. The question is, I don't know if you can see it. Is Facebook and our platforms considered to be protected under the First Amendment free speech, even though they're not individuals? And please explain. And along with that, in the part of the opinion where it's talking about Section 230, There was a word that I just had to laugh at, switcheroo.
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 Yes.
And
So
I'm not-
I'll address that. Yeah. Good questions. So corporations have First Amendment rights. Again, not necessarily obvious, but through First Amendment jurisprudence, they do. Citizens United is maybe the most famous one that says, you know, corporations don't, there were spending limits on campaign funds for corporations, and Citizens United sort of got away with that and some other things. They have First Amendment rights. They can speak freely as themselves. They can generate their own content, right? That's what the Texas legislature and the Fifth Circuit are saying. It's like, look, if you don't like what your users are posting, you have the platform. You can just post more of your own content to counter it. The marketplace of ideas. That's separate from commercial speech, which is treated with less scrutiny. Commercial speech is generally the types of things you would see in an ad, but not necessarily. It's got to be related to something that's being, you know, part of the business's sales or services, a statement about it. That's so commercial speech is, you know, like is treated with less scrutiny. The restrictions on what's in an advertisement, you know, for consumer protection purposes and things like that, is generally considered with intermediate scrutiny versus, say, strict scrutiny is what would normally be applied to content-based restrictions. So that's the baseline, and it is, despite what the Fifth Circuit has said, editorial discretion is found with what they call censorship is found throughout First Amendment jurisprudence over the last 50 years. I don't know, maybe longer. The concept that a private company has, a private publisher of information has a First Amendment right to curate that information. That's a baseline that doesn't exist in the Fifth Circuit suddenly. In fact, what I find, you know, again, I feel a little bit some sympathy for these platforms, because where's the quote? I can't find it, but basically at one point the Fifth Circuit says something like, instead of trying to create a historical First Amendment argument for why the law is facially unconstitutional, they simply turn to Supreme Court jurisprudence on the First Amendment. What do you do, right? I mean, I feel like that seemed appropriate, but I guess not. There is a long-standing tradition that private publishers have a First Amendment right in curating their content. So how do you get around this? Because now we only got 10 minutes left. So how does the Texas legislature and how does the Fifth Circuit basically saying, well, that's not really a thing? They say, in no way are we restricting the platform's First Amendment rights. Does not even qualify for rational basis scrutiny, because no First Amendment rights are implicated. And even if they are, Twitter, you can, you know, if you don't like what's on your platform, it's your platform and you can just keep speaking more on your own official Twitter account. And even if none of that works, the platforms are now common carriers. But that's, again, only one vote of the three supported that conclusion. The common carrier, at one point, the opinion says the platforms are no different from AT&T or Verizon. I'll leave that one as homework to you if you can think about any way that Twitter is different from Verizon. Again, whether or not I can make a phone call to you is different from whether or not I have a blue check on my name, right? So there are just some really like eye-popping sentences in the opinion. And because there's no First Amendment implications to anything that the law says. And then here's also what people are criticizing the opinion for. The tone and the language of the opinion is aggressive, I guess. It says, well, it's just so obvious that there's no right of censorship. This is so obvious. This is so obvious, right? And I remember going to law school, we were warned so many times, do not say something is obvious. Otherwise, you wouldn't be at the Fifth Circuit. And 50 years of Supreme Court First Amendment jurisprudence, right? Be careful with that obviousness, right? So already, so the opinion is like, basically is almost like saying to the platforms that they're just stupid to have even thought the way that they're arguing, because it's so clear that there's no First Amendment issues in play here. And at least for one of the three, it's so clear that they're now common carriers, which is a whole other ball of wax that, is interesting. Another item, there's a provision in the bill that makes it illegal to block emails based upon content. What does that mean? That hasn't even been addressed. That wasn't really addressed at all in the briefs. I'm sure it will at trial if we ever get there. What does that mean? That means goodbye email, because it'll be unusable. If email service providers are not allowed to block spam, because buy my stuff is viewpoint, right? I think you should buy my stuff. That's a viewpoint, isn't it? My stuff is good. You should buy it, right? That's basically, makes email unusable. That's just not even, we're not even getting to that part, right? So I guess with 7 minutes, because there's just so, I was wondering, how to fill an hour, and I'm like, oh, I guess we could probably fill 2 or 3, but because I'm about to do this in my cyber law class at 1:30 my time. We're my students wanted to talk about this, so this is a nice. I'm getting a warm up to class today, so I guess I could pause for some questions, but I have also some closing thoughts on some issues that I have not seen anybody bring up in any of the commentary. So,
all right. I actually had a question I wanted to ask, since there aren't any in the chat boxes right now. In section 230C2A, I'd like to talk about the phrase otherwise objectionable, because the law shields platforms from civil liability for any action voluntarily taken in good faith to restrict access or availability of material the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. And the court here on page 43 of the opinion reads this as meaning similarly objectionable. So if otherwise objectionable means anything the platform finds objectionable, they're shielded, for example, for censoring content critical of the government's COVID response. But if it means similarly objectionable, then censoring speech critical of the government's COVID response probably wouldn't be covered, because it's not similar to obscene, lewd, lascivious, filthy, or excessively violent speech. So what does the phrase otherwise objectionable mean in section 230?
Again, we can all put on our statutory interpretation hats. Is this a case of eius dem generis, right? Of the same kind, which is, when I say, you're not allowed to have cats, dogs, or otherwise in your home, or you can't have, or in the hotel room, I guess is maybe a better example here, or you can't have cats, dogs, or similar, right? What is it? The statute says otherwise. And if we're going to interpret statutes, we should start with the statute. That word, I think, was very particularly chosen, not similarly, which the court just sort of reads out otherwise and just throws in similarly and says the platforms don't know what they're talking about when they argue, wait, the statute says otherwise, not similarly. So I would argue, and I think at least a plain meaning, and you also skipped over one little item there that the court doesn't address. It's not just the platform, but it's the user, right? that the platform, the provider or the user finds otherwise objectionable, not similarly objectionable. So I think there's been a lot of discussion about that distinction even before the statute was passed, saying, well, 230's content moderation liability shield really only applies to things like obscenity and, you know, the really bad stuff. But if it's otherwise objectionable to the platform or the user, doesn't that include, you know, whatever I think is otherwise objectionable? If I have a website and I say, you know, you can do that. You can run a server from your basement and run your own website. And if I say, hey, I don't want to see any cats playing pianos, no talking about that, which you see in like Reddit groups, is that we're not going to talk about these things. This group is only for very specific things. Well, as a private actor, I have that right. At least we all thought we did. Unless I got 50 million users and whatever Texas says about common carry and all of that, right? So in my mind, it's sort of going down the wrong path to say, yeah, the statute really means similarly, not otherwise.
Thanks, Dr. Firestone. With only 3 minutes to go, we have some users who would really like to hear your closing comments. So
yeah, so I was just thinking about this stuff, walking around campus and, you know, trying to, things just hit you. And I'm like, nobody's even talking about the metaverse, right? If somehow Zuckerberg gets the dream of everybody's on the metaverse, 50 million users a month, can you imagine what the metaverse would look like without content moderation? There's already plenty of videos and content about sexual harassment, encouragement of suicide, right? Encouraging somebody to commit suicide is a viewpoint, right? There are things that there are just things that you would see in the metaverse, which we're already seeing, but Facebook would not be able to get rid of because they're a viewpoint, right? That is something I haven't even heard anybody talk about, which I think is really interested. People haven't mentioned, how you could game this. I was thinking, people could just game this. If I don't like Twitter today, I could flag some posts or ask somebody to flag my posts as controversial, get them taken down. And then I could, complain. You could see this process. You could see this becoming a very, very untenable process for a platform, because they have to also engage with almost like a due process requirement of notice and appeal. And this could happen with automated, right? So that alone people haven't talked about, because they just haven't gotten to some of these issues because they're just so surprised that I don't think there's a surprise that the law got passed, but I think there's just some surprises that, now we do have a circuit split, and what will happen if at the Supreme Court, you only need 5 votes.
Yep.
In fact, sometimes you only need 4, and some plurality issues. Will the platforms continue? So this is a lot of people saying this is the test of user generated content. Will we see a world where YouTube continues to allow everybody upload videos? Or will platforms say we can't even risk that because of all these issues? We can't have a different internet for Texas or Florida, and we're just going to have approved licensed content? Even that, I have questions about. So
it'll be interesting to see how it all plays out.
Yeah.
We have arrived at 10 a.m. Mountain Time. Thank you so much, Dr. Firestone. Yes. On behalf of the Law, Technology, and Warfare Research Cell, and on my own behalf, thanks for joining us today. Been a good conversation.
Well, it was an absolute pleasure, and I hope Air Force wins with the triple option this Saturday if they play. So.
All right, I'll be at the game. Hey, thank you very
cool.
much.
Thanks.
Goodbye.